Family law reform is on the docket in Ohio. Sponsors of Senate Bill 174 make some pretty good promises, citing goals to maintain parent-child relationships that are fundamental to the well-being of the child and to foster the relationship between a child and both parents. Laudable goals, given the estimate that only 1 in 6 parenting time orders in Ohio provide at least 90 overnights for each parent.
The problem is, those goals have been the official state policy since 1998. What has prevented Ohio courts from putting policy into practice over the last 27 years? The short answer is nothing. The one-parent, one-visitor model that was identified as problematic by Ohio Supreme Court task forces in 1987, 2001, and 2005 is simply a choice made by our judges and magistrates. What will Senate Bill 174 do to combat this parent sidelining culture?
According to the sponsors, words matter, and they will align the language of current law with the aforementioned goals in mind. And the language alignment is deliberate, meant to remove the perception that one parent may have the upper hand or more authority than the other. With so much emphasis placed on language, one wonders why they intend to remove only the perception that one parent has the upper hand and not the reality of such inequalities.
The truth is, there is no actionable difference between Senate Bill 174 and current law. The best interest of the child will still be subject to the preconceived biases of the jurist. More disturbing is the erasure of parental rights in addition of complete discretion for the court, moves that grant the state even more authority to dictate how our children will be raised.
Decades of research has made it common knowledge, if not common sense, that children do better when both parents are involved in raising the child.
Moreover, nearly 90% of Ohioans feel that children have the right to spend equal or near equal time with both parents.
To that end, in each of the past 2 General Assemblies, Ohio legislators have attempted to address the lack of equality, transparency, and accountability in current law. Both times, efforts were opposed by large special interest groups, namely the Ohio Bar Association and the Ohio Judicial Conference, the people who make money off our conflict.
Unsurprisingly, both groups are major proponents of Senate Bill 174, explaining why the bill does nothing to bridge the disconnect between what Ohioans know and want with how the court operates. It was not designed to.
Truly addressing the issues of family court would be bad for business. Written by the family law lobby for the family law lobby, Senate Bill 174 merely repackages a decades-old policy with meaningless platitudes that offer no genuine reform.
In other words, the expensive, adversarial, win-lose culture of family court will persist, as will the state-sanctioned destruction of the child-parent relationship. The special interests win.
And Ohio families lose. No on Senate Bill 174.